Good afternoon. The House Local Government and Municipal Finance Committee will come to order. Madam Clerk, would you please take the attendance?
Chair Fitzgerald.
Here.
Representatives Burns.
Here.
Shannon.
Present.
Green.
Here.
Rogers.
Here.
Hill.
Here.
Hoskins.
Here.
Pies.
Present.
Zorn. Paquette. Gazat.
Present.
McFall.
Here.
Preston. Mr. Chair, you have 10 members. You have a quorum.
Thank you very much, Madam Clerk. I need a motion from a member to adopt and approve the minutes from the previous meeting. That motion is made by Representative Breen. Seeing no objection, the minutes will stand approved. Today we have three bills on the agenda. House Bill 4693 regarding Open Meetings Act, House Bill 6015 through 6017, a Rep. Tsernoglou package regarding the shelter of animals, and Senate Bill 480, a Senator Hertel bill regarding land division. We're going to start today with Senate Bill 480 regarding land division. We have an H1 substitute to adopt. That motion is made by Representative Rogers to adopt this H1 substitute. Madam Clerk, would you please call the roll?
Chair Fitzgerald.
Yes.
Representatives Burns.
Yes.
Shannon.
Yes.
Green. Aye. Rogers.
Yes.
Hill.
Yes.
Hoskins.
Yes.
Pies.
Yes.
Zorn. Paquette. Gazat.
Yes.
McFall.
Yes.
Preston. Mr. Chair, you have 10 yeas. Substitute. Each one is adopted.
Thank you very much, Madam Clerk. We do have Stacy Hassong here from the Michigan Association of County Drain Commissioners. She's here virtually, I should say. She's not in the room, but is available for testimony, wishing to speak in opposition to the bill with some color for us to provide on the bill. Ms. Hassong, can you hear us, and are you ready to testify?
I can hear you, and I am ready to testify. Thank you very much, Mr. Chair.
You may begin when you're ready.
And so we appreciate the time to speak to this issue. And I think the last time I was in front of this committee, you heard more about drainage than you ever cared to. And I'm going to talk about it again today. So last time I was in front of you, I showed you all kinds of pictures of flooding and basement, flooding, road flooding. Unfortunately, we're still without that silver bullet that solves all of Michigan's drainage issues. And because we're continuously fighting drainage issues, we're concerned with the drainage impacts that arise with increased land splits without stormwater management issues being addressed. And so every time something is built, especially on a small piece of property, it goes from impervious surface to impervious surface. So it's a more intense, more water sheds from the property with every driveway, with every rooftop, with every garage, with every pool barn. And so when you're looking at an increased number of splits and you're looking at an amalgamation of all kinds of different independent drainage situations going on in a small, relatively small area at the same time, or even over the course of time, that causes us great concern. We're still dealing with the sins of the past before regional detention and subdivisions was required. And so this is a concern of ours. So right now, drain commissioners do not have jurisdiction to review individual drainage sites for residential properties. And so building permits might look at drainage a little bit, but really they're not in a position to do it holistically, and they're not looking at a bunch of houses going in the same time or in the same area and how that may impact it. They're looking at them in a singular fashion rather than a holistic fashion. And so this bill really doesn't address the stormwater protections that we're concerned about. And so we are asking that the committee consider an amendment to allow, if there will be increased splits, to allow drain commissioner to review and against their county standards to review this type of action, because I can tell you from my more than 25 years in experience in doing this, it costs a lot more to fix this after the fact than it does to prevent it in the first place. So as an example, when we're looking at properties where stormwater wasn't taken into consideration, and I could probably list one in each of your counties or many in each of your counties where that happened. Let's say in the 70s or 80s, no one thought about overall stormwater pictures. To go in after the fact, after houses are built, swimming pools are put in, everything's put in, it's multitudes more to do that than with the planning beforehand. So we ask that the committee consider amendments to require some review of the stormwater, either by a municipality or by the county to ensure that. I know there is some language with regard to municipal ordinances. However, many of those municipal ordinances don't require stormwater review at this level. In fact, our office represents over 100 townships. I asked some of our township attorneys, are we going to be covered if it's just the municipal ordinances? And they were very reluctant to say that it would, because they're not aware of any stormwater ordinances that cover it at this level of individual building sites. And so with that, I'm open to any questions that the committee may have.
Okay, thank you. My question is, I guess I just would like to know today, with the current splits that are allowed, what is the interaction with drain commissioners and drain surveys in today's world?
So with the 4 splits that are allowed, there's no interaction. There's no interaction. And so that causes problems, and we're dealing with it. But the intensity of going from 4 to 10 or more than that basically compounds a problem that we're already fighting. If I had my druthers, we would review all of these situations, but we're not asking for that. We're just asking for, basically, let's review what the statute currently has in it. We're not suggesting that there can't be splits. It just needs some drainage review.
Okay. No questions for you at this moment, Mrs. Song, but if you wouldn't mind just sticking around for a moment, we do have one other group to testify. We have Judy Allen from the Michigan Townships Association, going to be joined by Jen Rigterink from the Michigan Municipal League. There is a note here trying not to oppose, so I feel like there are opportunities here. I appreciate commentary when we get that on the card. So if you wouldn't mind sharing your testimony today, please feel free to begin when you're ready.
Thank you so much, Mr. Chair, members of the committee, Judy Allen, Michigan Townships Association. And yes, I would say we are the same. We're trying not to oppose, but we do oppose H1 that is before the committee today. And I would just say that, we have tried to work to get to a compromise that would protect locals and still allow more splits. We originally had the conversation with the sponsor to put language in that would keep it at 4, but allow the splits to be above that as long as they were in compliance with local zoning requirements. And that did not happen when it passed the Senate, so we've come back again. We're realizing they went from 10 or 20 down to 10, but again, our goal is to make sure those additional splits beyond that are currently above the current statute would be in alignment and with the local zoning authority. Jen, I'll turn it to you because I'm trying to be short.
Thanks. Thank you. Yes, trying not to oppose. And the sub that was adopted today with a little bit more finessing in language that has been provided, I know to staff and Senator Hertel, and being vetted, if that is adopted, we do not have an issue. If it's not, we're looking at splitting and then not having potentially developable lots. You're going to split lots that can't support infrastructure, can't support what this bill, the whole reason we're doing this bill in the first place.
And I should just point out that we did offer both policy staff, the chair's office, and the sponsor's office some proposed language that, again, would, if it were adopted, it would take us to neutral.
Thank you. No questions at this moment either. Appreciate your feedback. I apologize. We have one other group to testify. We do have the Michigan Realtors Association. Brad Ward would like to come and provide some testimony on this as well, speaking in support of the bill.
Hi, thank you, Mr. Chair, members of the committee. Brad Ward, Michigan Realtors, in support of the bill. Everything that you've heard from the drain commissioners, from townships, Michigan Municipal League, Eagle, all of these things are not currently provided for in the Land Division Act. The buildability of lots is never a question under the Land Division Act. That's left to local zoning. Local zoning is not touched. Local control to build is not touched by this particular piece of legislation. By going from 4 to 10, that's all it does, along with the infill language that's down below. Local control still exists for the buildability of lots. Drain commissioners still have oversight of drainage projects. Eagle still has setbacks that they can check against septic systems. Surveys can still be done. Some local governments require them, even though the Land Division Act says that it's not part of the approval process. Developers use surveys if they are going to build on these lots. Land Title Association, I know, had some concerns about surveys and wanting certified surveys, but at the same time, if you're going to issue a title policy, you can also make that a requirement that you have a survey in order to issue a title policy. So again, all of these things don't exist at 4. Why do they need to exist at 10? That's it.
Okay, thank you. A little balance to the commentary about this. Obviously, the sub that we've adopted, this is a change from 20 splits down to 10. So it does address some of the concerns that we heard in the first hearing about this regarding the density to the development and the land division. So recognizing that, I think we have helped to subside some of the questions that we had earlier this year when we brought this up the first time. We do not have any questions for you as well, Mr. Ward. We do? Excuse me.
Yes.
Representative Hill.
Just to clarify, I think the question that I heard in the previous testimony was about the unbuildable lots that might be created, and I'm fairly new to this process, so could you please, and I know we heard testimony on this before, but could you please just walk through how to make sure that it sounds like you're saying, well, all the lots would be buildable, and I am trying to understand that.
No, sorry. To clarify, the Land Division Act is never about buildability. That's what local zoning deals with. So local zoning exists outside of the Land Division Act. The Land Division Act exists to allow people to take their property and to split it. You can split it into smaller size lots that don't conform to local zoning for buildability. There's nothing that prevents that from happening currently. So the Land Division Act is about division, and then buildability comes into question. So people divide their property for all sorts of things, not just to build or develop.
Just a quick follow-up, because I am aware, I've had constituents contact me that where folks have bought lots sight unseen in the Upper Peninsula and then come to find out that there's actually no access and there's no ability to get these, bless their hearts to want to come to the EP, all in favor of that. But I'm truly, this is an issue that has come to my attention in my office here of people being sold land that was not buildable. So I guess. And you're saying, well, that, if I may, then you're saying, well, that's not what's in front of us. What's in front of us is just the ability to split.
Correct.
But if it leads to this kind of situation, I guess I don't understand the nexus maybe between the two?
I think you have to look at it from maybe 2 different situations where I would divide my property to create buildable lots or even a larger lot that I could build a subdivision in. But there's also instances where I may split my property to create another farm or open space preservation where someone wants hunting land or whatever it might be. So there are different situations. Like I said, it's about dividing land and not about building, which is why we've tried to keep the Land Division Act, and in particular this version of this bill, clean from any additional requirements on dividing that have to do with a whole bunch of situations that may not apply to someone who wants to divide their land.
Okay, no additional questions. I appreciate your commentary, Mr. Ward, and thank you for answering questions. With that, we are not going to look to report today. We are going to continue the work of developing any necessary substitutes. I do have some cards to read in, though, based on 480 as it stands today. Not wishing to speak in opposition to the bill, Troy Hagon from the American Council of Engineering Companies. We have not wishing to speak in opposition to the bill, Matt Soash, Michigan Land Title Association. And not wishing to speak in opposition, John Core. Not wishing to speak in opposition to the bill, Andrea Brown with the Michigan Association of Planners. Not wishing to speak in support of the bill, Dawn Crandall with the Home Builders Association. Not wishing to speak in opposition to the bill, Brett Hollinsworth with the Michigan Society of Professional Surveyors. Not wishing to speak in opposition to the bill, Michelle Batora, Michigan Society of Professional Surveyors. Thank you very much, everyone, for our discussion on 480 today. Next, we are going to bring up House Bills 6015 through 6017. Sponsored by Rep. Tsernoglou. These bills modify the care and treatment and definition of animals in a shelter. Here to provide testimony, we have Rep. Tsernoglou with a few guests as well. Excuse me. I believe that we have Chris Swanson with the Genesee County Sheriff. Am I wrong?
He's actually next. These
Coming
are
up next.
my guests from the Ingham County Animal Control
perfect.
officers.
Thank you. And when you begin your testimony, if you wouldn't mind introducing yourselves, that would be appreciated. And Rep. Tsernoglou, you can begin when you're ready.
Thank you, Chair Fitzgerald and members of the local government committee for allowing me to testify today. I will be speaking to the bill package sponsored by myself, Rep. Mentzer and Rep. McFall. Together, these bills seek to bring long overdue updates to the dog law of 1919. Despite over a century of progress in animal welfare, this outdated statute contains a loophole which allows neglectful and or abusive pet owners to keep their pets, even if a dog is visibly freezing, overheating, or even on the brink of death as a result of harsh weather conditions. The lack of clarity in the original law, which contains no shelter requirements based on specific coat length or breed of dog, has prevented local animal control agencies and other animal rescues from saving numerous dogs that were not properly protected from Michigan's seasonally harsh elements and weather conditions. Every year, or every 2 years rather, a version of this bill package is introduced when the temperatures start to drop and the weather gets dangerous on days like today. And every year thus far, it has slipped through the cracks and dogs continue to freeze to death. If you're like me, you have someone in your life, maybe like a mother-in-law or a family member or friend that tells you their neighbor has a dog that's barking and is outside and they don't know what to do about it. And they may even call animal control or the police, and then they're told that they actually can't do anything about it. And the same story happens in neighborhoods across our state every winter. These bills alter the existing definition of shelter so that thickness and length of the animal's fur or hair can be considered as a determining factor when deciding whether an animal's designated shelter provides adequate protection at all times to maintain the animal in a good state of health. This legislation clarifies that transport crates, crawl spaces under vehicles, decks, plastic barrels, and other forms of makeshift shelters are not adequate protection from harsh elements or weather conditions for dogs unless they have been modified to include proper temperature control or insulation. Now, I know that the bear hunters and maybe some other groups have concerns about the plastic barrels. However, they have assured me that their plastic barrels are modified to properly be insulated for the weather. So their plastic barrels are actually exempted in this legislation, so that should not affect them. By clarifying what constitutes adequate shelter throughout the state, it will ensure that all animals are protected equally and that all animal owners are held to the same standards. These bills will provide law enforcement agencies and animal control officers with a clear set of guidelines to help them assess whether or not an animal is being housed appropriately. Seeing as law enforcement agencies across the state are not equally resourced when it comes to the law enforcement or the enforcement of animal protection laws, many jurisdictions do not have access to dedicated animal control staff, and the burden falls upon the existing law enforcement agencies. The current animal protection laws are exceedingly vague, providing little structure or guidance for law enforcement to assess an animal's well-being. These bills provide a more detailed and equitable framework for assessing and protecting animals kept outdoors. Once again, thank you for your time. I have some officers from Ingham County Animal Control with me, and this issue actually was first brought to me last year by one of these officers, as well as some animal welfare groups. So I'd like them to be able to share their experiences as well. Thank you.
Thank you, Chair and members of the committee. Dan Verhoogstreet, Deputy Director with Ingham County Animal Control. I just want to voice our support for this bill. From a practical matter, the current language does very little to be proactive about helping animals survive in inclement weather. Right now, the wording of the bill only allows us to take action often after animals have suffered harm or death. The law currently addresses dogs as a whole when we're often referring to a 5-pound Chihuahua the same way we're referring to an 80-pound Husky in the winter, and that's just not appropriate. Some of these animals are more inclined to survive in hot conditions and cold conditions, and this proposed bill language allows us to more often state what shelter is not, and what the prohibitions in this law we see every single day. We see dogs living under steps, we see dogs living under decks, we see dogs living on wire cages every single day of their lives, and we can do nothing to stop this inhumane treatment because the law is written so vaguely. So I want to say from a matter of, as an agency administrator in Ingham County, we support this bill very much.
Thank you. My name is Kyle Haney. I'm a sergeant with Ingham County Animal Control. I am up here to voice my support for this bill as well. I would like to speak on a boots on the ground level and maybe provide some real world practical examples of where this bill could benefit not only your constituents but their pets as well. I do want to preface as well, as an animal control agency, our goal is not to have this bill passed in order to remove animals from homes. I believe our representative here actually said it best, that owning an animal is not a right, it is a privilege, and we just want to make sure that these people that are practicing this privilege have the tools in place to make sure that their animals are adequately cared for. Again, I've been an animal control officer in the state of Michigan in Ingham County for approximately 12 years. All of us in this room probably remember February of 2019, where we were all faced with the polar vortex. Given this, or at that time, there were many emergency operations personnel that were telling people to not be outside for any longer than 5 minutes at a time. We had animal control officers out during this period responding to animals being left outside. Some of these animals did have access to shelter, which at the time and currently they were not in violation of any law. This proposed bill does state that if elements and weather conditions pose an extreme health or safety to the animal, that adequate protection must be included. So having a bill that will also include these extenuating circumstances is going to be crucial should we face something like a polar vortex, where while someone may have a doghouse outside, a plastic doghouse or a wooden doghouse is not sufficient when it is 20 degrees below zero outside. On the other side of that, and I know many of us right now are thinking about the colder weather as it's getting colder outside currently, this bill also will protect animals in the extreme heat. Currently, it is legal and we cannot take any sort of action, corrective or otherwise, if someone leaves a dog outside with access to shelter when it is 100 degrees outside. Now, inside the shelter, it may be shaded and protected from the sun. However, these dog houses often will act as a microwave, and the heat inside the shelter can actually be hotter than the air temperature outside. How can we sit there and say that this shelter is providing the animal any comfort or relief from the shade at that time? One other example that I would like to give, and this House bill touches on it, that the residents of the dog owners or where the dog is being kept has to provide appropriate light, ventilation, and temperature control. There are many houses in the city of Lansing, particularly, where houses may have been condemned due to not having utilities on. Per city ordinance, people are not allowed to habitate these homes because they were deemed unsafe. However, their animals are oftentimes kept inside these houses still, even though they're not adequate for people. Our officers and our department can do nothing to provide any sort of relief for these animals because the house is a hard-sided structure which currently constitutes an adequate shelter per law. These are just some examples that I wanted to provide as to what this bill can provide to our animals, your constituents, and again, my support for it. Thank you for your time.
Yeah, thank you for the commentary about what this looks like on the ground. I think in today's news, you can probably find an article almost every week about the importance of animals to family members, to communities as well. They make communities, if you will, make a community a home, but they provide a great service to the community, to the families themselves. And so I think that when we talk about this, it's about the responsibilities of the owners, like you said. It's the privilege of owning a pet, and thus making sure that we have the ability to keep them safe in these extreme events. If we're out in 115-degree heat, especially me with no sunscreen on, I'm going to have an issue, right? But for an animal too, I've seen in my community, dogs who are sleeping under cars who are wearing a collar and chained to a cinder block because the access to their shelter is shade from underneath the vehicle. That is obviously, that made me feel uncomfortable when I saw that, but probably by the letter of the law today, there might not be anything that we could have done about that situation. So we do have a couple of questions. We do have one more person to testify, so I might like to have that testimony occur first and then pose questions to you all, but I appreciate you being here. We do have Chris Swanson, Genesee County Sheriff, to testify as well. If you want to remain at the testimony table, that would be great, and that way we can just have you all available for questions. Sheriff, go ahead.
Good morning. Good morning to my fellow sheriffs, retired but always a sheriff. Thank you for everybody here. This is an easy one. You're on the right side of the issue, in part. I come on behalf of a law enforcement executive that works hand in hand with animal control. In Genesee County, I do not oversee animal control. I work hand in hand with them, as well as the Humane Society and all of the incredible volunteers that I hope are watching right now, including some on this committee. But this is about basic humane treatment of companion animals that are not wildlife and not livestock. And I think when you look at the rationale, and I agree with, it's not just your right, but it is a privilege. And Mr. Chair, you said it best, it's a responsibility. And when you connect the treatment of an animal who is defenseless, and you don't hold accountability to that individual, and they take advantage of it, it's just a matter of time before it spills over into child abuse, elder abuse, and other abuses. And this is what we see in law enforcement. And again, my colleagues have seen it through a whole career. I think that it's important that we've highlighted some concerns with our bear hunters, and we have some exceptions. All this bill does is allow for insulated or protective care when animals are out. We realize that they're outdoors. So regardless of where you lie, this is the right issue to protect and to ensure safe keeping of animals that are normally held outdoor. This is simply clarity and compassion. What I do want to caution is page 10 of Bill 1615 when it comes to the exceptions for lawful killing. There is one particular line that I think should be discussed more, and that is the scientific research of animals. I think that if that's not linked to actual data, that this committee should take note of that. It's different than actual safe storage and keeping of animals, but I know that it is a hot topic of my community. I know that there are prohibitions, but just to note on that, if animals are going to be used for research, there has to be empirical data that benefits and just isn't in there as an exception without accountability. With that, I thank you for the bravery of our animal control officers and our Humane Society officers that go out every single day. You have my full support on the bill with that one exception. Thank you.
Thank you. Yeah, I sit on the Agriculture Committee as well for the House. We have a great deal of animal testing bills that do come before that committee. That is certainly something that is always a continued topic to ensure humane treatment of our animals. And I'd like to, thank Sergeant, Deputy Director, Sheriff for your service to our communities. I lived here in Ingham County for a time. I had a dog who lived on the property adjacent to ours. She was a beautiful kind of tiger striped pit bull. Called her Princess. I don't know if that was her name or not, but Princess had to deal with a lot of the circumstances that you're talking about, living under steps. That was the close to the polar vortex year. I think we got like 18 inches of snow in like 12 hours here in Ingham County, and saw Princess go through a number of really challenging circumstances. I think law enforcement was called, and there wasn't a lot that could be done in those circumstances. And this is something that the humane treatment of the animals is top priority, and really underscoring that responsibility of our constituents and the community members as well. We do have a few questions. I'd like to begin with Representative Pies.
Thank you, Mr. Chair. I was wondering, how do you put out the notification for this, since the fines are large? I'm thinking of people who are maybe innocently ignorant, if that makes any sense. And also, it would seem to me that the time that the dog is out, I'm wondering, like, the subjectivity of what's considered length of time.
And I'll just jump in real quick too, and I might maybe phrase one part of that a little bit differently. Is there has been a lot over the past 100+ years since 1919, when this would have been really first created, that people may have just a continuation of what they saw as humane treatment of animals from their youth that we would not consider acceptable today. And so by that kind of innocently unaware, it's just that continuation of a habit that was seen as productive and helpful at the time. So go ahead, Sheriff.
Great point. I can tell you that there's cultural issues, there are historic issues that people have been used to, but I will tell you, there's not a person up here in the enforcement side of animal protection that is not a teacher first. We understand to be unclear is to be unkind. And what this does, it allows us to know, is this a mistake of the heart or a deliberate mistake of the head? And this process that we're in is there because we still have a court to interpret, a prosecutor to determine, was this something that was taught in generations? Can we course correct? Is this something that we need to take in a more heavier stance? So what I love about this is it allows us to be clear on what we can do and open it up for that subjectivity where lawyers and prosecutors, defense attorneys, and other advocates can say, now let's try to fix this, or let's hold them accountable. So I think the teaching component is key. We do that on a regular basis. We use our ability to message, but I think that is key to let them know. But it comes down to also common sense. You know when a dog is freezing and when a dog is burning to death.
Yeah. Thank you, Sheriff. Representative Bagol.
Thank you, Mr. Chair. As Sheriff, I did oversee the animal control for the county, and sadly, this does happen way more often than people probably realize. So I want to applaud all of you for taking time out of your busy day to come here and do this. It's really meaningful legislation. So thank you very much.
Thank you. Representative Rogers.
Thank you. My first question is, what are the penalties laid out? So I'm sorry, I'm trying to quickly read through all the bills, but can the bill sponsor maybe outline what the penalties are?
I'm going to need to look for that too.
And is it a change? So that's my question.
There's no change in penalties here. It's just making it clearer what is considered adequate shelter and what's not considered adequate shelter, and how to make that determination. So it gives animal control and law enforcement guidance and the ability to actually enforce this part of the law. So it doesn't change any penalties. It just essentially makes this enforceable now.
Okay, and if you want to get back to me, follow up later, that's fine.
I'd look for the penalties.
So that part of this package I am supportive of, because I will just be honest, I represent a pretty significant marginalized community, and I have a hard time with the current law. I've heard about these things as a former county commissioner, with aspects of it being gray and having people complain about sometimes going a little bit too far. It's certainly case by case and not across the board, but there are some instances where people have had this grayness and then had some of these penalties unnecessarily. So I think it's a balance, right? And so I appreciate the clarification. I'm going to ask Sheriff Swanson to repeat because I was not quite ready for what you were going to say, and I 100% agree. So if you can again outline the bill and the line number you were referencing with the scientific experimentation piece.
Do you mind hitting your mic one more time just so we can make sure it's out there for our folks?
House Bill 6015, page 10, line 27 starts the language.
Yeah.
Next page, you'll see where it says scientific research.
Yeah.
Specific. My concern is, I understand, and as the chair had mentioned, there's a whole conversation, but if we are scientifically using animals with no data to support it, and I think the committee should take note of that.
Yeah, I really appreciate you bringing that to my attention. So I will just go on the record right now. Like I said, I was positive towards a lot of aspects, but I will absolutely not support this with that in it. I am adamantly opposed to severely limiting testing on animals. The fact of the matter is a lot of our medications in this state and in this country need to go through clinical trials, period. And I have a lot of life sciences companies in my area. I think a lot of us have family members. I have physical therapy patients that are on specialty medications, and we would not have those medications without animal testing. So I agree with you 100%. Thank you.
Also, I just want to clarify that that section is already in the dog law. So this bill that we're testifying today doesn't change that at all. Sheriff Swanson was just saying that he would like to change that. Okay. So that's just to, make sure we're clear on that piece. And I think it looks like the penalties start at the end of page 7. There's like 3 pages referencing different penalties, and it all kind of depends on like a lot of different factors. So.
Thank you all so much. We don't have any further questions from the committee. We will be looking to take this up for a vote next week, and we'll continue to have conversations with the bill sponsor. But again, appreciate all of you and your service. You do see some things day in and day out that many of us are not privy to, and so your experience that you were able to share really helps to enlighten, I think, the committee and also the public that we are continuing to try and educate because to be unclear is to be cruel. So thank you very much for your time and testimony today. With that, we do have a few cards to read in. Oh, excuse me, with some more to testify. Okay, we do have 2 more to testify. I have Molly Tomularic, and apologies if I messed that up, wishing to speak in support of the bill from Attorneys for Animals. Molly, are you with us?
I am. Can you hear me?
Yes, we can.
All right, excellent. Thank you so much. Good afternoon, Chair and committee members. My name is Molly Tamulevich. I serve on the board of directors of Attorneys for Animals, which is a Michigan-based nonprofit and 501c3 organization of legal professionals and animal advocates. And this bill is actually so important to me that I got up at 3 a.m. to Zoom in from Sydney, Australia, where I currently reside, because I have been involved in animal welfare organizations in Michigan for a long time and seen many iterations of this bill come and go. And it's just so important, I feel, to speak up for dogs across the state and make sure that they're getting the adequate care that they need, and emphasize the importance of passing this bill and taking action on it today. These bills provide much needed clarity and life-saving guidance to those charged with enforcing the state's animal cruelty laws. And thank you so much to the officers from Ingham County for so clearly articulating the need for this bill. So I just want to quickly and succinctly articulate Attorney for Animals' support of the bills in front of you today, and state that the amendments are going to make the jobs of animal control officers and others charged with investigating animal crimes easier, and it will improve the lives of animals. And we encourage the committee to report HB 6015, 6, and 7 out of committee. Thank you very much.
Well, thank you very much for your testimony. Thank you for joining us from the middle of the night and halfway across the world to do so. And I appreciate you underscoring the importance of this for our communities here in Michigan. No questions for you, Molly. I really appreciate you taking the time, though, to share this. I think a lot of folks in the committee room and outside feel similarly to you. So thank you very much. I do have now Ann Griffin with Michigan Humane here to speak in support of the bill.
Good morning, or good afternoon, I should say. Again, my name is Ann Griffin. I'm the Director of Advocacy for Michigan Humane, and Chairman Fitzgerald and committee members, I'd like to thank you for the opportunity to testify in support of these bills. And I'd like to thank Rep. Tsernoglou and the numerous co-sponsors for introducing the bills. Michigan Humane is the largest and oldest animal welfare organization in the state, with hundreds of thousands of constituents and supporters statewide. Michigan Humane works to improve and save lives through compassionate care, community engagement, and advocacy for animals. We are a private, nonprofit organization. We're not affiliated with any national humane organizations or any local or regional humane societies or SPCAs. House Bill 6015 would amend Michigan's animal welfare statute prohibiting animal neglect. And the focus of the amendments, as we've said during today's discussion, is on what constitutes appropriate shelter for outdoor dogs. While it's important for the statute to be broad enough to encompass a wide variety of scenarios and provide law enforcement, animal control, and humane investigators with discretion, it is also important to give those frontline responders clear and enforceable guidelines. And again, I would like to extend my thanks to the frontline responders who are there today testifying in support of the bill. The standard set by the anti-neglect statute is that animals should receive adequate care such that they are able to maintain a state of good health. The bill makes clear that when it comes to shelter for outdoor dogs, protection from weather that poses, quote, an extreme risk to the health or safety of an animal, unquote, is necessary. Michigan Humane's cruelty investigators routinely encounter animals whose health and well-being are jeopardized because they are living outside without adequate shelter. And you have pictures of some of the types of inadequate housing our investigators have seen that would be prohibited by the bill, which are included in our written testimony. Without a clear, enforceable definition of what constitutes adequate shelter for outdoor dogs, the law is left to the interpretation of individual pet owners, first responders, and the courts. The idea of what constitutes adequate shelter varies from person to person and from one jurisdiction to the next. First responders, such as Michigan Humane's cruelty investigators, would benefit from clear standards for appropriate shelter for outdoor dogs because, first and foremost, they would be used to educate pet owners, and that point was previously made in testimony today. In the absence of an emergency situation, education is always the first approach to addressing animal welfare issues in the community. If education efforts fail, it is important to have clear and enforceable standards in place so that necessary steps can be taken to ensure that animals are protected. This bill provides a common sense definition of adequate shelter for dogs so that the law can be applied equitably across the state. It does not apply to any other species, including livestock or wildlife. We respectfully request that you vote in favor of the bill, and thank you again for your time and consideration.
And thank you very much for your testimony as well. We do have the written testimony with included the pictures that you discussed, and so we'll include that in the committee record and make sure that the committee members have that. But thank you for your testimony. We do not have any questions for you, Ms. Griffin. Thank you very much for joining us. So with that, we will wrap our discussion around 6015 through 6017. I have a few cards to read in. Not wishing to speak in support of the bill, B. Friedlander from the Attorneys for Animals. Not wishing to speak in support of the bill, Mike Compagnoni from the Humane Society of the United States. Not wishing to speak in opposition to the bill, Mike Thurman with the Michigan Hunting Dog Foundation. Not wishing to speak in opposition to the bill, I apologize, Lisa Schaefer with the Michigan Bear Hunters Association. Not wishing to speak in opposition to the bill, Joe Hudson with the UP Bear Hunters Association. Not wishing to speak in support of the bill, Tanya Hilgendorf with the Humane Society of the Huron Valley. Not wishing to speak in support of the bill, Sarah Devaney, Michigan Pet Alliance. All right, and that does conclude our discussion on those bills for today. We'll continue to have discussions with the sponsor regarding any updates to the legislation before we hope to bring that forward for a vote next week. With that, we are going to go at ease call the chair. All right, the House Municipal Government and, Local Government and Municipal Finance Committee will come to order. We're next going to bring up House Bill 4693. This is a bill of mine. We do have an H2 to adopt. I need a motion to adopt the H2 substitute. That motion is made by Representative Rogers. Will the clerk please take the vote?
Chair Fitzgerald?
Yes.
Representatives Burns?
Yes.
Shannon? Breen?
Aye.
Rogers?
Yes.
Hill?
Yes.
Hoskins?
Yes.
Pies?
Yes.
Zorn? Paquette? Bazat?
Yes.
Pagol?
Yes.
Preston. Mr. Chair, you have 9 yeas, the substitute is adopted.
All right, thank you very much. So now we will go at ease very briefly at the call of the chair.
All right. The Local Government and Municipal Finance Committee will come back to order. Representative Fitzgerald, please begin your testimony when you're ready.
Thank you, Vice Chair Burns and fellow members of the committee for taking the time to take testimony on House Bill 4693. It does interact with the Open Meetings Act, and this would allow for non-elected, non-compensated, and bodies who do not have the ability to really levy taxes or fees to meet remotely. As we're aware, the pandemic changed how a lot of our lives is conducted. Currently, the Open Meetings Act, or the OMA, mostly requires meetings of public bodies to be open to the public and decisions made by those public bodies to be made within the act. As currently defined, a public body within the statute means any one of the following: state or local legislative governing bodies, including boards, commissions, committees, subcommittees, authorities, or councils, a lessee of such a body performing an essential public purpose and function pursuant to the lease agreement, the board of a nonprofit corporation formed by the city, and others. Really, what the pandemic showed, though, was that as it eased, it became less of a public health crisis and a public health need that would require these bodies to meet remotely. But it did show that there were boards and commissions that made more sense to allow for that remote access to meetings for a variety of reasons. Since the straight extensions from 2020, the legislature has really we've continued to carve out certain public bodies, allowing them to meet fully remote regardless of the reason. As of 2024, those bodies include an agricultural commodity group, the State Beef Industry Commission, the Michigan Potato Industry Commission, the Michigan Bean Commission, the Municipal Employee Retirement System Board, the joint agency formed under Section 3 of the Michigan Energy Employment Act. And in this bill, any circumstances requiring accommodations of all of the following must be met. So meaning there are 3 criteria that a board must meet in order to require the in-person meeting of that body. Really what that means is that if you are not all 3, remote attendance is possible. That would be that if you are, again, elected by the electors to serve on the public body, that no member of the public body is compensated for serving on that public body, and the public body does not essentially levy taxes and have that ability entrusted to them. That means that an appointed board or commission, like a planning commission per se, would have the ability to do this and ensure that, again, the largest group of that body could meet for access to the public. And access is still underscored here because the meeting of the public body that would be held electronically must be conducted in a manner that permits that two-way communication so that members of the body can be heard and can hear from members of the public. Participants must be able to hear the public body and can be heard by the body during public comment. And that's really the important part as well, is that they cannot then be inaccessible in a remote meeting setting. A public body may use the technology to facilitate typed public comments during the meeting submitted by members of the public participating in the meeting that may be read or shared with members of the public body. Members of the public body and members of the public participating electronically in a meeting held under this section that occurs in a physical place are to be considered present and in attendance at the meeting for all purposes. If a public body directly or indirectly maintains an official internet presence, that includes monthly or more frequent, that meets monthly or more frequently, and how persons with disabilities may participate in the meeting under this section and accommodates members absent due to military or a medical condition. So really what this is doing does a number of things, but really focuses on the remote participation and the underlying accountability of that board to either meet in person or remotely. The substitute that we've been working on, it's really to find the definition of public funds that makes sense and is not overly broad. That is one thing that we have been working on. It also helps to accommodate some work that we have done for retirement systems earlier in the year. The definition that we came up with in so much regarding the argument that could be made that any funds that a public body interacts with is public funds. But thus, in talking with stakeholders, we came up with the idea that if a body has the ability under law to directly raise revenue from taxpayers, that is what that's really the test that we're trying to hold our bodies and boards accountable to. Many raised concerns about the elected part of this as well, whether they were elected by the body of a retirement system per se, or of public electors. That is something that we were looking to clarify, and we thought that was really clarified by saying that no member is elected, should be really to say no member is directly elected to serve on the public body in question. So this should help to clarify some of these scenarios where members may be appointed by a board, like a planning commission, a parks and rec commission, or otherwise. And I thank you for your time and look forward to continued testimony on this as we consider the passage and the support of this to the House floor.
Thank you, Representative, for your testimony. We'll now take time for member questions. Representative Hill, please go ahead, and then we'll get to our other members as well.
Thank you. Really glad to have this in front of us to clarify these issues as we are facing a giant snowstorm between me and getting home. I'm really glad. My question then is in that laying out of it was that question of the public funds. That was something, because does it also mean that there needs to be, because I was part of a body, the Upper Peninsula Energy Task Force, that made recommendations on how we might potentially want to prioritize funds, for example. So again, no authority to make a decision, but we were asked to make priorities. So I don't want to nitpick language here in committee, but that has that been raised, that question of we want people to participate, or a population council that was appointed by the governor that is making very important recommendations about the future of our state. How would that be addressed in this situation?
So this bill specifically it doesn't take into consideration really the importance of the work per se, whether you're an appointed committee on the city of XYZ that has the ability to make a recommendation that you pay a band $5,000 to come and play at that, or if you're on the Michigan Population Council and you're focused on really large scale recommendations. That doesn't come into factor here based on the recommendation that we have, that it would really be the ability to raise revenue by imposing the tax, millage, assessment, or fee on said persons. And so, again, if you have a committee in a local government situation who's making a recommendation to the city council, the city council is then that body that would be required to be in person, would not have that remote access ability based on this bill here, 4693.
Thank you, Rep. Hill. Representative Rogers.
Thank you. Well, I'm generally supportive of this, but everyone in this room would be very disappointed if I wasn't consistent and said the same thing I always say with all of these one bill efforts. I'm very appreciative of this, but we need comprehensive overhaul. And so I'm still looking forward to having comprehensive overhaul so that our other units of government, particularly our locals, can have some kind of provision as well. So thank you for this effort. I think it makes sense how you laid out the financial piece and the guardrails around it, and I'm generally supportive. Thank you.
Thank you, Representative. And I would say that there is continued conversation. I think the frustration is that there is piecemeal, understanding and also requirements placed on local boards and commissions. That frustration is felt by myself and others. That, I believe, is still coming. This is a bill, though, that can help us take a step in the right direction to accommodate some of these boards where remote attendance makes sense, and also for the public as well, ensuring that their public comment can be made through that two-way communication.
Thank you. Representative Pies.
Thank you, Madam Vice Chair. I know when our council had met several times during early pandemic, we had to state where we were located, and so I'm wondering if that's part of this, but I'm also wondering if there's a limit to the numbers of meetings that may be virtual during the year.
That's a great question, and that is something that has been brought up in conversation kind of on this larger OMA overhaul. That is not specifically prescribed in this bill. I would tell you, though, that I think that some of the habits and lessons that we learned from the pandemic would be best practice that would probably be followed, because that is really kind of the test balloon, if you will, that we had was during COVID. We had the ability to build some of those habits about naming your location. Where are you viewing this from? Establishing the two-way communication. It's not prescribed in this bill, but I believe some of those habits that would be, overseen by clerks and others who are presiding over the meeting would be potentially best habit. And I wouldn't doubt that that is actually something that might be coming in other bill sets down the line to help provide more clarity to that situation.
Are there any further questions from members? All right, seeing none, Representative Fitzgerald, thank you for your testimony. We appreciate it. The committee will now go at ease.
The committee will come to order. We have one more person wishing to testify. That would be Jen Rigterink from the Michigan Municipal League. Ms. Rigterink, if you wouldn't mind coming forward, you may begin when you are ready, wishing to speak in support of the bill.
Thank you. I will try to be brief. We very much appreciate the work that has been done in this first step. And to Rogers, your question, we thought that taking this piece and going forward, maybe it would show that remote meetings aren't the big scary thing, even for electeds down the road. So we really appreciate this first step in trying to, one, catch up with just the technology, but also accommodate. There are not folks lined up outside of city council or city hall, village hall, township building, submitting applications to sit on boards and commissions. And so this also allows for some flexibility when you're looking for someone with particular expertise. One of our members has a retirement, I'm forgetting the name of the actual commission. I'm going to blame it on my cold medicine. But they're working with hedge fund folks that work in finance, folks that are advising them on making and recommending to them to make solid financial investments to help with the retirement funds that their community has. And so if that investment person, that expertise is going to go on vacation or they happen to be out of town, being able to still access that expertise and knowledge is crucial for our members. So thank you, and we look forward to continuing to work with many of you on future OMA reform.
Thank you very much. Yeah, I think that the comment made about people having the ability to put themselves forward for boards and commissions that may be appointed, but having that accessibility now to participate is important. I think every community across the state is kind of seeing a reduction in interest in serving on these boards and commissions, and this might be an opportunity to help to open an avenue for broader participation for people who may be working still during or working out of town for that matter during the scheduled meeting time, and allowing them to step away and be participating remotely. So there are no further questions for you, Ms. Ringtrink. Thank you very much for your testimony. I do have a few cards to read in. Not wishing to speak in support of the bill, Debbie McCula with the Michigan Library Association. Not wishing to speak in support of the bill, Noah Smith with the Michigan Association of Public Employee Retirement Systems. That is all the cards on 4693. That will conclude our discussion on House Bill 4693. We need a motion to excuse absent members. That motion is made by Representative Pies. Seeing no objection, members are excused. And seeing no further business before the committee will stand adjourned.